So to correspond with the readings of Chapter 1.1, we're going to talk a little bit about the United States Supreme Court oral arguments, and that is particularly interesting given the time that we're in. So I'm going to provide some context about how Supreme Court oral arguments have worked traditionally versus how they actually work currently, considering there has been a significant change. I'm going to talk a little bit about the format of oral arguments. Then I'm going to transition into a portion discussing the readings for this week, which is the lack of diversity of the Supreme Court bar. And then I'm going to add some context to that, discussing some relevant research about why diversity on the Supreme Court bar actually matters. So most of you should know as observers that currently the Supreme Court is holding oral arguments in a new format for the first time since the court's inception. The Supreme Court currently is hearing oral arguments via teleconference, which means that all 9 justices and the attorneys for each side of the case are dialed into a teleconference, and the oral arguments are happening that way in a time of social distancing. Another unique aspect that has added to this is that the oral arguments for the first time in history are being live broadcast, meaning that any interested observer can listen in real time to the Supreme Court's oral arguments. Historically, the Supreme Court has provided audio of oral arguments available, usually within days after the oral arguments have taken place. But this development of live streaming of the oral arguments is significantly new. So while oral arguments that have gone on the past 3 weeks have taken a new route and provided an opportunity for an average citizen to listen in real time, that has not always been the case. Supreme Court oral arguments before the pandemic were scheduled for 30 minutes for each side. That meaning that each side of the case got 30 minutes to present their case to the court sitting en masse. In rare circumstances, the Supreme Court would extend the time of the oral arguments or give other parties, primarily amicus, the ability to have arguments before the court as well. But those are in very rare circumstances. In most circumstances, the 2 parties in the case each get 30 minutes per side. Now, that does not mean that an individual who is representing either the petitioner or respondent gets 30 minutes to talk interrupted, presenting their side in the case. As is tradition, the justices can interrupt the attorneys at any point during the oral argument to ask questions, to clarify points, to present hypotheticals, and to attempt to better understand the argument that the attorneys are articulating. This has oftentimes led to interesting back and forths among the justices, interrupting the justices. The attorneys are oftentimes talked over by the justices. And with the transition to the new format, Chief Justice John Roberts has, in essence, done away with that, as each individual justice is given a set time to ask questions. What this has, interestingly, has happened is that a notoriously quiet judge during oral arguments, Justice Clarence Thomas, is now very outspoken and has asked questions in every case that the court has done via teleconference. And this is not shocking. Justice Thomas had said previously that he didn't like the sort of free-for-all technique of the in-person oral arguments. And now, perhaps because oral arguments are staggered in the way they are and that justices are called upon for their questions, he feels more at ease asking questions and has played a significant part in the new tradition of oral arguments. Now, the lack of diversity in the Supreme Court bar, the focus of this topic, deals primarily with those attorneys who orally argue before the United States Supreme Court. As the article demonstrates, the Supreme Court bar is not an overwhelmingly diverse body. It is exceedingly white and exceedingly male. Beyond just that. It is also exceedingly elite. Individuals who practice in the Supreme Court bar and orally argue before the United States Supreme Court primarily come from the top tier of law schools, the top 20 law schools in the United States. So the bar, this select group of individuals who participate before the Supreme Court in terms of oral arguments, are not at all representative of the public, are overwhelmingly and historically overwhelmingly have been white men, and that voices of individuals, men and women who are minorities, are seldom heard before the United States Supreme Court. Part and parcel, this should not be very shocking. If one were to look at the historical nature of the United States Supreme Court, we know that women and minorities are not overwhelmingly present as justices on the United States Supreme Court. And during this historical era, it's also true that those who are arguing before the court were not exceedingly diverse. Now, one might question, uh, if individuals are trained almost entirely at these exclusively elite law schools, does it matter? Does it matter that the Supreme Court bar is not overwhelmingly diverse? It does not have a lot of female voices, does not have a lot of voices, individuals who are of minority status? And the answer by relevant research is yes, it actually matters. Shane Gleason, one of the authors of a chapter in the book that we're actually going over, has analyzed the types of questions and interaction between Supreme Court justices and attorneys during oral arguments, with a look at, do justices treat women and people of color differently during oral arguments than they treat white men during oral arguments? And the answer is resoundingly yes, they do. And that effect is not dependent upon the gender of the justice. It is dependent upon the gender of the participant in the oral argument, the gender of the attorney. Now, being treated differently in oral arguments might be different, perhaps could be different, than being successful in oral arguments. By that, I mean actually winning your case. And what Dr. Gleason finds is that when individuals portray the stereotyped expectations of their gender, they are rewarded. So when men are more domineering, sure of themselves, exacting in their talk, they're rewarded in terms of success in oral arguments. But when women are more meek, are more discretionary, are more responsive to questions of the court, they're rewarded in terms of on the merits decisions going in their favor. So why then would I connect these two ideas, the lack of diversity in the Supreme Court bar to success during oral arguments? Well, if we assume that oral arguments matter, and research tends to demonstrate that they do matter with regards to who wins the case, what it means is that individuals have to play into the stereotypes of what is expected of them to be successful in oral arguments. That means that expectations for men engaging in oral arguments are significantly different from expectations pertaining to women. And this probably is not just confined to oral arguments. This is probably confined to the larger legal environment as a whole. Increasing diversity of the Supreme Court bar, which would probably mean increasing diversity within the national bar itself and within practicing attorneys throughout the country, might actually serve to change these expectations that the judges have with regards to oral arguments and sort of change the nature of justice, and that expectations would not be different for men as opposed to women in the Supreme Court bar. And that's why I think this article points to something that is very, very important, because we know that diversity has an effect on outcomes especially as related to oral arguments. And this article demonstrates that despite 20 years since the previous study had been done, really nothing has changed with regards to diversity of the Supreme Court bar.